The first person on the list is Deb Stevenson.
Hi, yes, I'm Attorney Deborah Stevenson, and I am with the Connecticut, People of Connecticut Incorporated Constitution Lobby. I'm here on Flag Park Road, Roxbury, and I'm here because it's come to my attention we have a controversy of sorts about a book, The Bluest Eye. And so I just did want to just address that issue for a minute from a legal perspective and perhaps ask some questions that you might want to consider in dealing with this controversy. The first thing that I think every government official needs to ask whenever you're proposing something or dealing with an issue is, do you have the authority to do this? And first of all, in order to determine that, you need to look at the Connecticut Constitution. And I just would like to bring your attention to one thing, and that's Article 1st, Section 5. No law shall ever be passed to curtail or restrain the liberty of speech or of the press. And Section 4, that every citizen may speak freely, write, and publish his sentiments on all subjects, being responsible for their use of that liberty. That last phrase is important because, yes, we have the right to publish and distribute information, but we also have a responsibility about how that's done. And that brings me to the next step in analyzing what your responsibility is, and that goes to the statute. And in this case, the question becomes, what is obscenity, and is this an issue that we need to bring, and can we bring it, if it is obscenity, to minors? So looking at the statutes, there is a definition of obscenity in the statutes that I would like to call your attention to, and that's 53A-193. And this deals with material or performance is obscene to minors if it depicts prohibited sexual act, and taken as a whole, it is harmful to minors. So that's the definition of obscenity as to minors. Now, then you have to go and try to figure out, all right, what does it mean harmful to minors? Well, the statute also defines that. It means that quality of any description or representation in whatever form of a prohibited sexual act when it predominantly appeals to the prurient, shameful, or morbid interest of minors, is patently offensive to prevailing standards in the adult community as a whole with respect to what is suitable material for minors, and taken as a whole, it lacks serious literary, artistic, educational, political, or scientific value for minors. So then the question becomes analyzing this particular book and or parts of it to the statute and applying that, and whether there are parts that are obscene according to the existing statute. Now, going down to a prohibited sexual act, I understand in this book there is reference in quite graphic manner to incest, for example. Incest is a prohibited sexual act according to our law 53A-191. Then if you go down to a couple of other statutes that you need to keep in mind, risk of injury to a minor comes to mind. That's 53-21.
I'm sorry, I'm going to need to ask you to wrap up your statement.
I will. Risk of injury to a minor, and the DCF statute of definitions of moral neglect and sexual abuse, and the fact that teachers under 17A-101I also are responsible in that anyone can report a teacher for distributing obscenity to a minor or morally harming a minor. And so my question is, when you're analyzing what you need to do with this particular issue, I would urge you to look at the statutes and to ask whether or not you want to accept this kind of liability, because that is a real issue, that people who may believe that this material is obscene or is objectionable according to our law can take action about that. And I would urge you to strongly consider that in your contemplation of this book.
Thank you very much.